Good afternoon, everyone, and welcome to another question and answer session live. My name is Samara Belitzky. I'm an employment lawyer in our Ottawa office at Samfiru Tumarkin, and I will be here, as I usually am every couple of weeks, to answer all of your questions related to the workplace, anything related to employment, the workplace, severance, terminations, layoffs, vaccination mandate questions or vaccination policy questions. Whatever the case is, whatever you've had on your mind, if it's you, a friend, a relative, we're here for the next half an hour to answer your questions. So send in all of your questions and I will be happy to answer them. We're still getting lots of questions over the last few weeks about vaccination passports and mandates and policies, as well as mask mandates as these things start to be removed from the provincial government standpoint. So lots of questions about that. This is a very hot topic in employment law right now. So if you have any questions about that, please send them in. I will, as we wait for some questions to come in, I will provide a bit of general information about especially the mask mandates and the mask related questions, because we've been getting a lot of that over the last little while. I have one question that we're going to answer right away, and then we'll get to the rest of them as they come in. So we had a question that was previously asked from YouTube, from Lou Ko, who says that they seem to be on a leave of absence from November. They aren't unionized. Every April, I sign a new contract. This year, HR included vaccination requirement in the contract. If I don't sign it, can HR terminate me without severance or consider it as I resign without severance? So that's a fantastic question. The short answer is no, they can't. So generally speaking, if an employer wants you to sign a new contract, and this is something we deal with all the time, this does happen, where either you start a job without a contract and then later on, years later, maybe they want you to sign a contract, or maybe you started with a contract, but years later, they want you to sign a different one. The first thing that's important to know is that usually when an employer is doing that, it's to protect themselves. It's to limit their liability in some way, and it's usually advantageous to the employer. Employment contracts are not usually advantageous or beneficial to the employee. So the first thing you want to do if you're getting a new contract and your employer wants you to sign it is contact an employment lawyer and make sure that you get it reviewed so that you know what it is you may sign or may not sign depending on the circumstances. We provide contract reviews all the time. Certainly you can contact us at employmentlawyer.ca and we'd be happy to help you with a contract review. You should not be signing anything unless you get it reviewed by an employment lawyer first. And then the other thing to keep in mind is you don't have to sign the contract. So no matter what, you don't have to sign the contract. It may be that you lose your job because of it. An employer may not want to continue to employ you if you don't sign the contract. And they are allowed to do that. They are allowed to terminate employment because you refuse to sign, but they do have to give you your full severance entitlements, your full termination entitlements. Now, with respect to a vaccination requirement, the same thing applies. If they were to include a vaccination requirement in the new contract, that is something that you should absolutely not agree with. You should not agree to sign the contract with that type of requirement in it, unless, of course, you're okay with that. But my recommendation would be not to agree to it, not to sign it, because that does create a precedent for the future. And if you don't sign it, they have the right to let you go, just like they would in any other circumstances. It would be a without cause termination, meaning, as I mentioned before, they'd have to give you your severance. They'd have to pay you your full severance. So in a situation like that, if you don't sign the contract, to answer the question specifically from YouTube, yes, they have to provide you with severance. They can terminate you, but they have to provide you with severance. They cannot consider it to be a resignation because it's not a resignation. The only way it would be a resignation is if you actually resigned from your employment and said, I quit, and you left your employment. That would be a resignation. And in situations where somebody quits or resigns from their job, that person would not generally be owed severance. So as long as you don't actually quit, they cannot take the position, or at least they cannot take the position successfully that you've resigned. You can choose not to sign a contract, and if they terminate you, you're owed severance. But there is no situation in which you refusing to sign a new contract that contains new terms and conditions of your employment. There is no way that would ever be something that constitutes a resignation. Okay. So if you're in that situation, definitely get in touch with us. If you're going to just outright refuse to sign, as I mentioned before, you have the right to do that. You never have to sign a new contract. You're never obligated. And you certainly can get in touch with us if they refuse to pay you severance in the event that they terminate your employment. So I'll continue. We have a bunch of other questions coming in. I have a question from Kim on YouTube who asks, can you be legally fired in Ontario right now for refusing to mask all day? Other details Kim provided. I mostly work alone behind a closed door and have offered to wear one if coming within close contact to others. So with respect to the masks, this is a question we've been getting a lot because the mask mandates are removed. So it's no longer mandated by the provincial government in Ontario to wear a mask at work. However, many employers are continuing to keep a masking policy in place for the time being. And that, again, for the time being, would be considered reasonable. This is an ever-developing, it continues to develop, the situation with COVID. So for now, it is still going to be reasonable for an employer to require their employees to wear masks at work. At a certain point in time, and hopefully that time is very soon, it will no longer be necessary. It will no longer be reasonable for an employer to insist that a mask be worn all day. For now, it will be considered reasonable. So if there is a policy in place requiring masking, as an employee, you have to comply with it. The only exception to that would be if you have a disability or a medical condition that makes it difficult or impossible for you to wear a mask. So if you do have, for example, a respiratory condition or some sort of medical condition where you can't wear a mask either at all or all day, maybe you have to take breaks, you can do it a little bit at a time, then you would have to be accommodated by your employer. So in order to make sure that you get accommodated if you're in that type of situation, you have to provide a doctor's note. So on the employee end, your job is to provide a doctor's note. You go to your doctor, you get a note that says, because of a medical condition, you either can't wear a mask or here are the restrictions for the mask wearing. As I mentioned before, it might be that you can only wear it, an hour at a time, whatever the case may be. Make sure your doctor's note outlines those restrictions and the requirement to be accommodated. Then you give that note to your employer. You make sure that you do it where there's confirmation or proof that the employer has received it. So what we usually recommend to our clients is to do it by email, because then you have proof that they actually received it. You would provide that to HR or to whoever in the workplace would be in charge of dealing with this issue. Sometimes it's HR, sometimes there's a health and safety person that's appointed for this. Whatever the case may be, as long as you provide that note, the employer then has an obligation to accommodate you up to the point of what's called undue hardship. So as long as it's reasonably possible for them to accommodate you, yes, there may be a minor inconvenience, but as long as it's possible for them to accommodate you, they have to do it. So in the situation like the one that Kim described, if let's say there was a medical condition at play here and there was a need for accommodation, something that could be an accommodation on the employer's end would be, having that person be isolated. So not wearing the mask because they can't, in an isolated area, social distanced, away from other people. So there's a lot of accommodations that can be made possible with the masking, especially, simply because most workplaces do allow for social distancing. So as long as it's possible, the employer has to do it. Another example could be, if it's in an office environment and there's no social distancing possible, maybe that person works from home for the time being until the policy is no longer in place. So there's all sorts of different things that can be addressed that can be put in place as an accommodation. But the first step, if you are in a situation like what I've described, is to provide that doctor's note, and then you go from there. So in a situation where there is no medical condition, maybe you just don't want to wear a mask as a personal choice because you're sick of wearing masks, as I think a lot of us are. But for the time being, if your employer has put in place a policy where you have to continue to wear a mask at work, that policy will be considered reasonable for now. And I want to make sure I stress for now, because these things will change. And at a certain point, it won't be reasonable. And you have to wear a mask for the time being. If you refuse to wear a mask in face of this type of policy, you could be disciplined for it as a type of misconduct. I have a question from Yuva from YouTube, who asks, were there any successful cases without court hearing in getting severance pay for employees who've been for several months on unpaid leave for non-vaccination? So I can't speak to every case, because unfortunately I'm not aware of every case that's out there. We would only really be aware of our firm's own cases. Anything else that may have settled, we would not be aware of unless it's at our firm. I can tell you that our firm has successfully negotiated severance for people who have been put on unpaid leave because they were not vaccinated. Every situation is different. So it really will depend on a bunch of different factors, most of the time, including whether the employer is willing to negotiate. Because if they're not, then you do have to go through the court process, which unfortunately takes a certain amount of time. And that's why we haven't seen any of these vaccination cases come out of the court yet. We haven't seen any decisions rendered by the court about this particular issue yet, because it's too soon. There are lots of cases where clients or employees have started court claims and have started to go through the process, but it's the early stages of the litigation process right now. So those cases would not have gone to court yet. They absolutely will, and hopefully over the next few months, we see more guidance coming out of the court on this. It will absolutely go to court at some point this year, given the timelines with the court delays, but nothing yet. So for the time being, yes, there have absolutely been cases that have been negotiated, either severance, as you were asking about, or returning to work. Because if an employee is put on an unpaid leave, there's also the possibility of returning to work. And many of the people that we've been assisting, a lot of our clients, some of them don't necessarily want to pursue severance. They just want to get back to work and keep working. So in those cases, we can pursue that rather than severance, of having that person return to work with back pay in order to keep working and continue. So it really just depends on the employee's preference as to what they want to pursue. Certainly, we're happy to help people pursue severance or getting back to work, depending on the circumstances. So if you are someone that's in that situation, certainly you can contact us. You can go to employmentlawyer.ca. You can email us at help@employmentlawyer.ca in order to speak with a lawyer and figure out what you can do in your situation. Because if you have been put on an unpaid leave or suspension without pay, or you've been terminated for cause because of your failure to be vaccinated, as long as there wasn't a government mandate in place at the time that this happened, you certainly would be owed severance, and you could pursue it with our assistance. Just to answer, so I have another follow-up question from Kim on YouTube, who asks if retail pharmacies have been ordered by the government to implement mask mandates at this point. So no, to answer your question, pharmacies do not have, there's no provincial mandate in place that obligates pharmacies to implement a mask policy as part of the workplace policies. Almost all masking mandates have been removed at this point. So that includes retail pharmacies. I have a question from Steven on YouTube who says, I worked on a fixed term contract for 3 months. I went past the 3 months without an extension and then was let go in the 4th month. Am I entitled to a notice period or severance? So with respect to fixed term contracts, if you, Stephen, have signed a contract that said, on X date you're going to start, on Y date it's going to be the end of your contract, and it really delineated the exact term of your contract. If you worked beyond that end date that was outlined in your contract, then the contract doesn't apply anymore. So if you have a fixed term contract in place, but you work beyond the slated end date, the contract is no longer applicable. So you would still be employed. You would still have a contract of employment. You'd have an employment relationship with the employer, but the actual written contract wouldn't apply. So they'd still have to, pay you the same that you were earning before, the same hours, all the terms and conditions of your employment would be the same, but the contents of the contract wouldn't apply. And why that's important is because sometimes you sign a contract that says it'll end on this date, and there might be a termination clause that talks about what your severance might be. But if you work past the end date, the termination clause, if there is one, and even if it did limit your entitlements, theoretically, no longer applies. For you, Stephen, because you were in a situation of a 3-month contract, it's very possible that your contract may have said your contract will end on this date and your employment will end on, X date. And there won't be any severance because during the first 3 months under the Employment Standards Act in Ontario, there wouldn't be any notice or severance owed if the contract specifies that and specifies that that would be a probation period. So if, let's say, your contract said that, and then you continued to work past the 3 months, you absolutely would be owed severance in a case like that because your contract no longer applies. So you should definitely get in touch with us. In terms of your severance, you can use our severance calculator. You can go to our pocketemploymentlawyer.ca and you can get an idea of what your severance might be. It'll depend on the circumstances, your age, your compensation. You had 4 months of service. So usually for 4 months of service, your severance isn't going to be a year, for example, but it can be significant and it can be much more than what you might think. Most people come to us and think it's, for 4 months, you might get 1 week. That's not the case necessarily. Under the Employment Standards Act, the bare minimum for you, Stephen, is 1 week because you had under 1 year of service. But that's just the bare minimum. That's just the starting off point. And then we would negotiate from there. You could be entitled to, up to 4 months of severance. It just depends on the situation. So definitely get in touch with us. You can contact me directly if you'd like. All my contact information is on our website. If you go to employmentlawyer.ca, you can find my profile and find my contact information. And I'd be more than happy to look at your contract and see what it said. But like I said, the contract doesn't even apply anymore. And you would be owed your full severance based on your 4 months of service. So keep that in mind in terms of moving forward. And for anyone out there that's dealing with something similar, again, the fixed term contract only applies until the actual end of the fixed term. So if it continues after that, the contract is no longer applicable and you would be in an employment relationship without a written contract. So keep that in mind, especially for severance negotiations, because oftentimes employers may let someone go and rely on something that it says in the contract, but the contract no longer applies and you could be owed much more severance than what the employer is offering you. So always make sure to contact an employment lawyer. Make sure you get everything reviewed before you sign or accept anything. I have a question from Julia on YouTube who says, my employer has us sign new contract terms annually and says we are classified as contract workers, but I'm not sure if this is accurate. How would I know if I am classified as an employee? So in terms of knowing what your status is as a worker, there are 3 categories. Commonly, we talk about independent contractors or employees, but there's also a 3rd category called dependent contractors. And so when you're looking at determining somebody's status, there are a bunch of different factors that we look at, but the main element that we look at and that the courts look at is the degree of control that the potential, employer or company has on the worker. And that can be gathered by looking at different circumstances like who supplies the tools for you carrying out your job, But that's not always something that applies these days. This is, that's more of a traditional factor. Who sets your hours of work? Who decides how you carry out your work? Who decides what you get paid? Do you have a fixed salary, and no matter how you perform, do you get the same salary? Do you get the same pay? Or depending on how you perform or how much you work, which is within your own discretion, you may make more or less money from 1 week or 1 month to another. So all of these things are part of the analysis, but it really comes down to that degree of control. And if an employer or if the company has a very significant degree of control on the worker, it's very likely that that worker will be an employee, regardless of what it says in the contract and regardless of what the employer is telling you. So if the company is telling you you're a contract worker, you're an independent contractor, it doesn't matter. If you're signing a contract every year that says, I agree that I'm an independent contractor, that also doesn't matter. Those are not things that the court would look at in order to determine your status as a worker. They look beyond those things. They look at the actual relationship between the parties in order to determine what you are. And so if you are also in exclusive employment, if this is the only job you have, and let's say it's the only job you've had for the last 20 years, the odds are you're going to be an employee or at the very least a dependent contractor. That's the third category that I was mentioning that most people don't know about. So a dependent contractor would be in the middle of the two categories of employee and independent contractor. But as a dependent contractor, you benefit from all the same entitlements as an employee. So if you're let go, you are owed severance as an employee or as a dependent contractor. Most of the time for dependent contractors, the difference between whether you'll be an employee or a dependent contractor could be that you have two jobs. It may be that you've worked for the same company for 20 years, but you may have another job on the side that maybe makes up 10% of your annual income, but this company makes up 90% of your annual income and has been that way for 20 years, 10 years, 5 years, whatever the case may be. If that's the case, then you may not have exclusive employment with this one company, but you're dependent on them for your making a living and for earning your most of your income. That's a situation where you would be a dependent contractor. And again, the distinction is not important because whether you're an employee or a dependent contractor, you will be owed severance. With respect to these contracts that your employer or the company, depending on your status, is having you sign every year, a lot of employers will use that as a tactic to try to argue that somebody's length of service is shorter at the time of termination. So if a company is putting you on, 10 years in a row, each year you have a 1-year contract, the result is that you're a permanent and indeterminate employee. Even though each contract says you're being, employed or your services are being retained for 1 year, if you do that several years in a row, those become a situation where it's successive contracts and it leads to indeterminate employment. So you're not a 1-year employee, even though you've signed a 1-year contract. If you've signed, 8 contracts in a row, year after year, you're an 8-year employee. And your severance would be based on your full length of service going back to the beginning, not just your most recent contract. So that's something to be aware of as well, Julia, in terms of, if there's a situation where you're going to be let go or anything related to your length of service. You're certainly not a 1-year employee. You have to go back to the beginning. So I have a question from Lydia on YouTube who says, I worked for a company as a technical sales person on July 20th, 2021, and I was laid off on September 10th, 2021 without severance. So it looks like you had, a couple months here of service, Lydia. Depending on the terms of your employment, you would still be owed severance. So if you didn't sign a contract, you definitely would be owed severance. If you did sign a contract and it laid out the fact that during the first 3 months you were going to be in your probation period, and you wouldn't be owed severance or notice of your termination during those 3 months, then you may not be owed severance in that particular situation. I am assuming when you say laid off that it was a termination. If you were laid off, put on a temporary layoff, and you weren't outright terminated, you also have the ability to treat that layoff as a termination and go after your severance. So depending on the circumstances, there's a very high chance here, Lydia, that you would be owed severance. So if you're not sure and you wanna pursue that potentially, get in touch with us. We can take a look at the relevant documents, speak with you, and see if there's something you can do to pursue this, because based on what you've said, there's a very high chance that you are owed severance. I have a question from the Dreamer on YouTube who asks, can my employer decide they are not going to pay for my sick day off, even if I provide a doctor's note stating I was sick? So in terms of sick days or sick leave, there's a minimal amount of sick days that an employee can take. But importantly, sick leave or medical leave or a sick day does not have to be paid unless your employer has a policy that provides you with paid sick days. Okay, so when we're talking about, let's say, COVID, there are specific COVID sick days that have been mandated by the provincial government where there are days where you have to be paid. There's a certain amount of days that have been mandated by the government that if you are sick with COVID, you have to be paid for those days. If you aren't sick with COVID and your employer has a policy where you have 5 sick days a year that are paid, that's great. You could take those 5 days as paid days. Once they expire, once you've used up all 5, then you're back to unpaid days. If your employer doesn't have a policy where they pay you for sick leave, then it's unpaid. In terms of what might be available to you to receive income while you're off sick, you could apply for EI sickness benefits. That's something that is available. The other thing you could do is if you're going to be off work for a longer period because you have a more serious disability or medical condition or injury, you can apply for short-term disability benefits and then long-term disability benefits if you have a policy in place. So to answer your question, it's possible that they don't have to pay you for taking a sick day, regardless of the doctor's note. It just depends on what policies your employer has in place. So Sunny from YouTube says, I've been employed with the same company for 16 years. The company was acquired a few years ago and they have sent a new employment contract. There's a clause in this new contract stating that I waive my rights to any common law entitlements. I'm trying to follow here, Sunny, because you've sent a lot of messages. I see here you're saying you don't want to sign. Are you obligated to provide a reason to decline? So I touched on this actually earlier in this session in terms of introducing a new employment contract. So just to reiterate a little bit, you don't have to sign. Generally speaking, if a new employment contract is being proposed, you don't have to sign. You also don't need to provide a reason if you refuse. So you don't need to provide a reason for refusal. You may want to if you are open to negotiating, and if your employer is open to negotiating that contract, you may want to decide that. But it's difficult. It's difficult to say specifically because I haven't seen the contract. But in essence, they can't force you to sign. And if you're having issues with respect to this, Sunny, definitely get in touch with us. We can review the contract for you. We can let you know where you stand. But you shouldn't sign it, especially because of the items you've listed here. If you already know that they're limiting your termination entitlements in this contract, you should not sign it. If you've never signed a contract before, or even if you have, the odds are that your previous contract doesn't impact your termination entitlements. And so you definitely don't want to be just abandoning your rights to full severance and giving up your rights to full severance. You should not sign something like that. But if you do require assistance in terms of dealing with the company, definitely get in touch with us. We'd be more than happy to help you with that. So we're just over our 30 minutes here. We've gotten a lot of questions today, and I'm sorry I haven't been able to get to all of them. So if your question was not answered, we do have another question and answer session on Monday. So tune into that and you can ask your question again. Otherwise, feel free to send your question to us at help@employmentlawyer.ca and we will get back to you that way. But absolutely, you will get your question answered. Unfortunately, we just ran out of time today and I can't get to all of them. So thank you very much for joining us today. And I hope that everybody has a wonderful weekend.